an act relating to firearms eligibility requirements. This is characterized as a code cleanup. We have done a lot of good freedom action since 2017. That has led to a few inconsistencies or references that are either no longer applicable due to changes in Iowa code or actually some federal court cases. So it's a little bit of a cleanup. I don't know how substantive anybody wants to call it, but it seems smaller to me than our last one. So with that, I see we again have several people online. Use the raise your hand feature when we come to you online, if you'd like to speak. I believe we have the volume problem of the last session addressed. I think we had a stuck key, but I think we have it addressed. So with that, do the senators have any opening comments?
I'm just looking forward to the discussion.
Okay. And then I'm going to go ahead and start with the gentleman who found some of the issues that we have in the bill. Richard Rogers, would you go ahead and introduce the bill?
Thank you, Mr. Chairman. Richard Rogers, Iowa Firearms Coalition. The genesis of this stems back to 2021 when we passed permitless carry in Iowa. We eliminated the requirement for a permit to carry weapons in the code. Iowa law used to basically state that thou shalt not carry a firearm or a dangerous weapon, except. The major exception was if you had a permit to carry. But there were occasions where if you did not have a permit to carry, or even if certain persons were not eligible to get a permit to carry, they could still carry, say, outside the city limits if their gun was not in a vehicle, was not concealed, say they were hunting, target shooting, and so on, or on their own properties. In eliminating the restrictions, we necessarily eliminated the exceptions. And because we did not wish people who couldn't get, for good reason, a permit to carry, they had a bad record. We did not want them to be able to carry just because permits were no longer required. So 724.8 is persons ineligible to get a permit to carry. New section 724.8B was created, persons ineligible to carry dangerous weapons. And that's where we began to have a bit of a problem, or it developed over time. It was inadequately drawn. Some of that we were aware at the time, but it became more obvious later, particularly since in 2022, the Supreme Court in this Bruin decision threw out a 113-year-old permitting law in New York because it was subjective. And of course, they also threw out the laws that 6 other states may issue permit laws. You may not have subjective criteria. It has to be objective. So this bill addresses inadequacies in 724.8B, which I can, and frankly in 724, due to the change in Second Amendment jurisprudence post-Bruin 2022. Also, in the permitless carry law, we made an error, a one-word error back in 724.15 and .16 having to do with a license to permit to acquire a pistol or revolver. The error was that the word possess was used instead of carry. And that section referred back to this new section, 724.8B, persons ineligible to carry dangerous weapons. But back there it said persons ineligible to possess dangerous weapons. This caused a problem because the courts grabbed onto that and started sentencing people who had misdemeanors, serious or aggravated misdemeanors. Their sentence included a ban on possessing dangerous weapons for 2 or 3 years, tied back to 724.8.8b. So while that was in there, I've tried to fix this since 22. It's passed in the House earlier as part of a larger bill that wasn't taken up in the Senate for unrelated reasons. So this fixes that. And the way it does it, it strikes that line that was in error in 724.15 because it's no longer necessary with what else is done here. It corrects it from possess to carry, as it references 724.8b in 724.16. So back to 724.8 and .8b, in persons ineligible to carry or to get a permit to carry, we have had a restriction which this would remove. You can't get a permit to carry if you're addicted to alcohol. Well, that's obviously subjective. Who makes that determination? In the case of a permit to carry, it would have to be the sheriff, but under what criteria, when, and so on. But the qualifications or the disqualifications in 724.8 for getting a permit were included by reference in 724.8b, ineligible to carry dangerous weapons, and they don't work. They don't work there. So in a permitless carry situation, there's no one to determine that you're addicted to alcohol under any, by the way, that's unique in the state, according to, in the country, according to DPS, we're the only state that has that, and they don't quite know how to deal with it either. So this would strike addicted to alcohol because it's subjective. It also doesn't work in the permitless regime. There's another one where the sheriffs had, when we went to shall issue in 2010, law was passed, it went started in 2011. The sheriffs were prior, they had absolute discretion to deny permits. Now they were given what I always called a fig leaf of discretion, and that was that if prior, when a person applied for a permit, if there was probable cause to believe, based on documented evidence, at least one instance which was within 2 years prior to the date of application, then the sheriff, that they'd be a danger to themselves or others, then the sheriff could deny. Well, that was incorporated by reference into the ineligible to carry dangerous weapons, but who's to make that? There's no application there and no date of application, so on. It just doesn't work. So this would strike that. Also, now, while we could accept that the sheriffs could still deny a permit for that reason, what would be the point? Because that person could then just go and carry without a permit if he wasn't actually disqualified for any other reason. So this fixes that. It smooths off some rough edges and takes into account what's happened with the Supreme Court and lower court jurisprudence since 2022. I know it's confusing. If you have other questions, please ask.
We'll work our way around the room. Oh, here, I'll take that. Who would you like to? Okay.
My helper. I'm Connie Ryan. I'm with Interfaith Alliance of Iowa Action Fund. We're registered opposed to the legislation specifically because of the alcohol, removing that and removing that prohibition. And I have some information from Johns Hopkins Center for Gun Violence Solutions. And I think we can all agree that Johns Hopkins is a very good hospital and research facility. And then I just lost my reference. Well, I've lost where I was gonna, so I apologize. But the essence of it is they're recommending, Johns Hopkins is recommending several items that should be included in law, or at least considered to be included in law. One section is to limit access by persons with record of alcohol misuse, and they have several suggestions of how that can be. And to Richard's point of if there is violation of an OWI like twice, then there should be consideration of not having. So I can send you that information because I've lost where I want that. But
Would you like us to come back to you after we go through the group?
no, that's fine. I'll just send it to you. The other piece is to limit access where alcohol is consumed. And I know this bill doesn't address that, but those are two areas that help with safety for the person, safety for the public, and making sure that you're not tying, that you're making sure that alcohol use is being considered when you're prohibiting the use of or the possession of a gun or carrying a gun. So I would send that information to you. I apologize.
Or you can come back if you like.
No, it's fine. It's fine. I'll just send it to you. So, yeah. Yeah.
Oh, well, that went quick.
Senator, I just want to make sure everyone understands that Iowa Firearms Coalition does not advocate drinking, mixing with firearms, nor do we think it's okay to be addicted to alcohol. It's just that there's no way to make that determination. There's no criteria in the law, and so it doesn't work as it is, and it certainly doesn't work under the permitless regime. That's the problem.
Okay. Online, we've been around the room. All in-person testimony statements have been had. I do see Nick. Nick, you've got your hand up. Go ahead and unmute, and we think we fixed the volume problem.
Okay, can you hear me well now? Or?
Yes, very well, just like we normally can.
Okay, perfect. I appreciate that. So, kind of like you described in your opening statement, this is really just kind of cleaning up some leftover language. I think that the legislature's intent was always to move from a may issue to a shall issue state. Between that, our stance is there are on those issues. I mean, in addition, it's also a long list of federal, disqualifiers. You know, anybody that has committed a crime, a misdemeanor, domestic violence, if you have controlled substance issues, anything like that disqualifies you from owning a firearm. So I feel like, you know, this bill just kind of cleans up and makes true what the intent of the legislature was, which is a May issue situation. It's also, you know, the courts have also agreed with that interpretation on a national basis. As far as any concerns, you know, there's always a process and court orders. If people shouldn't be owning firearms, they should have a day in court and not be, you know, subjected to, you know, a sheriff in this case or any other kind of rumors or hearsay on what their, you know, mental health is, whether that's, you know, addiction or other issues.
Alrighty. Thank you very much. I don't see any, oh, I heard something, but I don't see any other hands up. And with that, okay, I think we're done online. Thank you for watching online. Senators, it's to us then. Would either of you like to have a statement?
Right.
Totally going first. I just see this bill basically as code cleanup, just looking to honor current law. So appreciate the bill, and I'll be signing off.
Well, as you can imagine, I have the opposite view. Any assertion that the determination of alcoholism is subjective is just ludicrous to me. If a person has been hospitalized for alcoholism, that's a pretty objective term. If a person is a member of Alcoholics Anonymous, if a person has been arrested for repeatedly arrested for crimes related to alcohol, whether it's brawling in a bar or OWI or domestic violence, those are all very objective criteria for helping to determine alcoholism. You're also apparently removing any restriction with regard to people who are, quote, likely to use a weapon unlawfully or in such other manner as would endanger the person's self or others. I have a person who's pretty close to me, I've known for many years. She once upon a time was married to someone who had a drinking problem and an anger management problem and ultimately a violence problem. Had he had access to firearms, she would probably not be with us today. So I'm sorry. This bill, you claim it's just a technical change. It seems to me to be much more substantive. It seems to open the door to people who are inclined to drink to excess and who have other tendencies which will predictably lead to an increase in violence. I can't support that.
I don't have much to say. We're complying with federal law, or federal jurisdiction, and just changing to update the new paradigm that we have in our dangerous weapon code. I can't imagine this. There's no evidence of any of this doing any good before. It's not going to do any good after, and no other state does some of this stuff. So we're just going to clean this stuff up. With that, we'll go ahead. I've signed already. Senator Westrich, you're invited to sign, and we will go ahead and put it on the Judiciary Committee agenda for Wednesday.